As the current term of the U.S. Supreme Court is winding down, we're going to discuss a couple of significant circuit splits on bankruptcy issues that the High Court very well may resolve at the term to begin in October of 2018. On these installments of Rochelle's Daily Wire Video Edition, we have already covered the three opinions on bankruptcy law handed down the current term by the U.S. Supreme Court. Now we're going to look at a couple of issues that they very well may decide to tackle beginning in the new term to begin in October. Both of these cases involve stark circuit splits. The first relates to a frontal assault on a 1985 decision by the Fourth Circuit in an infamous case called Lubrizol. In that decision, the Fourth Circuit said that if you reject an executory license for intellectual property, the licensee has to stop using the property such as trademarks, patents, and the like. Congress roared to the defense and 3 years later adopted Section 365N, which provides that despite rejection, the licensee can continue using some types of intellectual property, such as patents and technology, but didn't say anything about trademarks. And as a result, there has been a split among the courts, some saying that rejection of a trademark license ends the ability to use the license, and others say it doesn't. In 2012, the Seventh Circuit stepped into the dispute and held in a case known as Sunbeam that rejection is just a breach, and nothing about breaching a contract ends the licensee's right to use a trademark. That seemed to be the notion that was carrying the day until early in 2018, in January to be more precise. The First Circuit decided a case called Mission Product versus Technology. In that case, the First Circuit said that, guess what? Lubrizol, the Fourth Circuit, got it right. If you reject a trademark license, that's the end of the story. The licensee has to stop using the trademark. There was a petition for certiorari filed in June, and that petition likely will be considered by the justices at their so-called long conference in late September, and we could hear by late September whether or not the Supreme Court will grant certiorari, and if they do, I suspect argument will be sometime around December of 2018. The second case is also a circuit split. This comes out of the Ninth Circuit, which held in April that if someone has a good faith belief that their action is not a violation of a discharge injunction, then that person cannot be held in contempt. The Ninth Circuit even went on to say that if your belief that you're not violating the injunction is erroneous or unreasonable, you are nonetheless not liable for contempt because you had a good faith subjective belief. Well, that decision appears to be at odds with decisions from the Fourth and the 11th Circuits. There is currently a pending motion for rehearing and rehearing en banc in the Ninth Circuit. And if those rehearing motions are denied, I have it on pretty good authority that the losing party is going to file a petition for certiorari. That'll come in maybe sometime late this summer, again with the possibility of argument in the Supreme Court if they grant certiorari, either late this year or in early 2019. Well, that's what we have for today's installment of Rochelle's Daily Wire. For more about these cases and a wealth of other information, please consult my column on the ABI website, where you will find much other in the way of resources useful for those in the bankruptcy arena. Until this time next week, this is Bill Rochelle saying good day.